maybe circumstances and time are in our favor at this stage, in the sense that even if we started with her now, we wouldn't finish. And I request leave of the court to stand her down. And we will speak to her and reassess the situation, and when the court reconvenes to finalize the mitigation arguments, we might have her here and she might decide not to testify.
Thank you.
I cannot push her now. I don't think it's right. And I feel it would be doing that. She has too many unfair pressures on her, and it do her no harm to have 2 or 3 months to think about it.
Absolutely. Thank you. I assume you have no problem. Thank you. Mr. Rohde, we're going to carry on next year, and Mr. Van der Spy and Mr. Master is going to have a chat with you to see whether you'd like to still continue to testify. And if there are any wishes that you'd like me to take into account, you can communicate it via them, and I will consider that. In an endeavour to make this very painful path that you're walking on more manageable, and to help you in any way whatsoever in dealing with it. Okay? Thank you.
Thank you, my lady. My lady,
She may step down.
may she be excused?
You are excused, Mr. Rohde.
My lady, as I said, I do have other witnesses, but the same applies to them now. They are Mr. Just for the record, Mr. Craig Fleischer and Mr. Craig Livingston, 2 business colleagues, good friends of Mr. Rohde. And then I have Mrs. Brenda Rohde, who she was there now, and that will really be all in terms of witnesses. If I may just address the court on this aspect of bail, then, my lady. My lady, the unusual situation has arisen. I know that sentencing was initially scheduled for 2 weeks ago. A lot of reports and things and factors arose, and the court considered an application for postponement and postponed until today, and I realized that 2 weeks has also played a role, and the effect is, as I understand it, that the accused is now going to be, unless bail is granted, incarcerated, awaiting sentence until probably somewhere in the middle or towards the end of February. I feel that that is an extraordinarily lengthy period of time in the circumstances. I appreciate fully that he has been convicted of a serious offence, in fact, 2 serious crimes, and I appreciate also fully that in the absence of the defence being able to prove the presence of compelling and substantial circumstances, that he faces a minimum period of 15 years imprisonment. However, he has not yet been sentenced. I do believe that his track record in terms of cooperation and compliance from the time of his wife's death being found right until the present, well, until his bail was estreated, was as close to 100% as one could possibly get in the circumstances. I do submit that inter alia, on the basis of Dr. Stolof's evidence, there was no issue of his malingering in February this year, that the uncontested evidence is that he was keen to carry on with the trial. Other than that, he made a statement to the police on the day that his wife died, without attorneys, without anybody getting involved. He just sat down and wrote it out of his own accord. It was a poorly drafted statement, but it was a voluntary one. He didn't want to duck and dive behind a legal representative at that stage. He made himself available on the same day to be clinically examined by the district surgeon, who cancelled the examination. He went back to Johannesburg. He was asked to fly down to demonstrate things to the police. He got on the plane. He flew down to Cape Town. He was told he was a suspect. He voluntarily went to the forensic pathologist to be examined, and then from when he was charged and arrested, to the letter and in spirit, he complied with every single bail condition over all that time. He never slipped up on one thing. I know the court would always warn him to be here at 9:30. He was always here punctually. If I came early, I'd always find him here. He never missed one signature at any police station during that entire time. He never, ever failed to ask for permission from Sergeant Apollos if he wanted to go down to his place in Plettenberg Bay or up to Johannesburg or leave the magisterial district. He was a truly compliant person. He owns 3 passports, which is a matter of record. One is a British passport, which has expired. One is an Australian passport, and one is a South African passport. Both of them are current, the last 2. They are all in the possession of the police. He cannot leave the country's borders. I must just say that his asset base has clearly been decimated by the consequences of this case and all the huge costs and expenses and things like that associated with it. He no longer has a house or access to a house in Johannesburg. That was the one registered in his wife's name. The only immovable property, is I understand the figures that he has in his name, is the Plettenberg Bay property, which he regards as his permanent place of residence, although he has, for the sake of this case, occupied and rented a flat somewhere in Greenpoint, and he's never changed that address. Furthermore, his children regard this as his place of residence, and we are at quite a crucial stage. It's quite clear from the evidence of the estate administrator. We're at quite a crucial stage, education and so on and so forth, of these children. They're about to go to university. You can see that there is a problem with finances. At the moment, there's only the amount of 80,000 cash available. The children are at a crucial stage, I believe, where they need their father most right now, following his conviction and before he gets sentenced. The devastating effect that this has had on the children, one can see without even listening to this witness through the report of Mr. Perry. The children regard him as their father. They regard him as their rock, as their source of guidance at the moment. He is, legally speaking, their only guardian at the moment.
Well, there are majors. You mean their parents?
Yes,
parents.
yes. Let's say parent, and in a sense, maybe I should say, even though they are now legally majors, they are totally dependent still, and will be for at least 3, 4, 5 years until they graduate or qualify or get jobs or whatever their plans are. My lady, bearing in mind the fact that despite the seriousness of the offence, for all practical purposes, Mr. Rohde does not constitute a flight risk. In February, we will not hear that he's a fugitive from justice sitting in some South American country. That just will not happen. How could it happen in any event where the only ties that he has left in his life are his parents and his daughters? And of course his good friends in South Africa, such as the 2 who are going to testify. And I asked the court, particular regard being had to the length of time that inevitably must now pass before he is sentenced, that the court grants him bail. At the moment, I understand that an amount of 100,000 rand was previously paid in for bail, and I think it's still there. It hasn't been collected yet by Mr. Mostert. I must just mention that there's also a bail bond. I think It's for R1 million, and I accept that the court might want to retain that if it grants bail. The only problem is that is costing, in terms of insurance cover with the bank, something just less than 20,000 rand per month. So that's a whole child's university education and accommodation per year that insurance for the bond covers. And then, my lady, I've been advised that if there was still to remain any doubt, my learned which you can be monitored day and night, more than happy to have to visit a police station on a daily basis. If those extras as a measure, an unnecessary one. So, my lady, the long and the short of what I'm saying is, I do believe that taking into account his excellent track record and taking into account all the personal circumstances, particularly the ones relating to the children, and I've lost the opportunity also of us hearing the one child temporarily, that it is in the interest of justice for him to be granted bail in this interim period, particularly when one takes into account that it's 2 or 3 months before the sentencing will take place. So I beg leave that the court grants this bail.
Thank you.
Lady, the state is opposing what I understand is an application based on new facts, because as I understand the law, that is the only reason why this court can entertain this application. And my first submission would be there are no new facts placed before the court. Dr. Stoller's evidence was heard in mitigation of sentence. That aspect was not canvassed with cross-examination, because that stage there was no such application based on new facts before the court. The only circumstance that has changed, and that is that there's going to be a postponement for 2 properly when the decision was made that bail, and that is the position that this accused should be remained in. Unless there's anything else the court wants to hear me.
No, it's fine.
Thank you.
Thank you, Mr. Van der Spy. Are you exercising the right to reply?
In a sense, the question of his compliance was clarified through the evidence. We also heard the extra evidence relating to the dire financial position of the children. I mean, as we stand here now, there is only 80,000 rand cash available for them. The minute, I should have maybe added, and if my learned friend wants to answer this, information was also, of course, relating to Mr. Rohde's interest in the property business in Johannesburg. If he goes to jail permanently, that, of course, will be compromised. But the most important circumstances I would submit at this stage is the fact that a period of in the vicinity or in excess of 2 months will now necessarily pass because of the festive break and the first and January, the first week of 3 full bench appeals, and then other commitments, that we could be looking at 3 months before he is sentenced. And my submission is that that is a circumstance which renders, which opens the door to the court applying the principle
As a new fact.
As a
new fact.
Thank
Exactly
you,
what
Madam.
Thank you. This is a bail application based on new facts. As Mr. Van der Spy indicated, the new facts are essentially that the sentencing proceedings, which started on the 21st of November, which could not proceed on that day, the defense team had applied for a postponement on the 21st for 2 weeks, and it proceeded yesterday, the 5th. The court had, as you would recall, ventilated on a previous occasion on the 21st. The situation would be difficult going forward if undue time is spent on preparation of the sentencing for the defense and that it not get underway. That being said, furthermore, Mr. van der Spade indicated that Mr. Rohde's conduct whilst out on bail is, in light of Dr. Stolof's evidence, must be seen as having been formidable and exemplary, and I must consider that in an application for bail now. As regards the children, the court accepts that this is a very difficult time for them. I am, however, satisfied as far as the children are concerned that notwithstanding as onerous as their path of healing might be, that they are well loved by their extended family, and notwithstanding the grief for all the relatives concerned, they have, and by all accounts, appear to be taken care of by their families. That deals with the aspects of the children. The fact that the matter has not yet finalized is to a large extent brought about by the defense's application. Had that not been the case, the court would have been well able to finalize sentencing, and as such, I do not consider that the reality that we now have to postpone the proceedings till February as a justifiable and new fact. The crimes of which the accused have been convicted are serious and grave, and I'm not persuaded that it's in the interest of justice that bail be reinstated or granted to him. Accordingly, Mr. Rohde, you will be remanded in custody, and this matter will proceed on the Monday, the 18th of February, 2019. Thank you. Court is adjourned.